Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secret and non-compete law. Today, we are doing a year-end wrap on the top 10 trade secret and non-compete developments of 2024, a year perhaps like no other in this area of the law. My name is Pete Steinmeier. I am the managing shareholder of Epstein Becker Green's Chicago office and co-chair of EBG's Trade Secrets and Non-Compete Subpractice, along with my partner and friend, Eric Wybust, in EBG's Boston office. Eric is with me on the pod today. Eric, it's always great to do an episode of Spilling Secrets with you.
Likewise, Pete. Good to see you.
Eric and I are delighted to be joined today by our newly elected partner, Millie Warner in the New York office. Millie, congratulations on being elected a partner at EBG. And welcome back for another episode of Spilling Secrets.
Hi, Pete. Thanks so much. That means a lot. And I'm really excited to be here for our episode today.
Also joining us today from Boston is our partner, Kate Rigby.
Hey, Pete.
And last, but certainly not least, our partner, Dan Levy, who is joining us from EBG's Newark office.
Thanks, Pete. It's great to be back.
As I mentioned a minute ago, this has been a year like no other in this space. And what better way for a group of non-compete nerds, like the five of us, to end the year than by counting down the top 10 trade secret and non-compete developments of 2024. With that, I am going to start things off for the group with number 10. The Georgia Supreme Court allows employee non-solicits that lack express geographic limits. Back in the summer of 2023, the Georgia Court of Appeals issued a decision in North American Senior Benefits LLC versus Wimmer that presented potential challenges for employers seeking to enforce employee non-solicitation provisions. That case held, pursuant to Georgia's Restrictive Covenants Act, that a restrictive covenant extending beyond the end of an individual's employment and undertaking to prohibit the individual from soliciting former coworkers is unenforceable if it lacks an explicit geographic limitation. But in a September 4, 2024 opinion, the Georgia Supreme Court overruled that decision, resulting in our number 10 issue of the year. The Georgia Supreme Court held that nothing in the text of Georgia's Restrictive Covenants Act mandates that a restrictive covenant contain an explicit geographic term, nor does it prohibit a covenant's geographic area from being expressed in implied terms. Rather, the Georgia Supreme Court continued, Georgia's non-compete statute only requires, with respect to geographic restrictions on competition, that any such restriction be reasonable, regardless of whether the restriction is expressly stated or merely implied. To be sure, the Georgia Supreme Court's opinion is a boon to employers seeking to enforce employee non-solicitation provisions, but it does not mean that such provisions are always enforceable. Indeed, in remanding the case to the trial court, the Georgia Supreme Court reminded that court of the applicable standard, namely, the geographic scope of employee non-solicitation provisions must be assessed for reasonableness in light of the totality of the circumstances, including, but not limited to, the total geographic area encompassed by the provision, the business interests justifying the restrictive covenant, the nature of the business involved, and the time and scope limitations of the covenant. In other words, Georgia now applies the same geographic standard as nearly all other states that enforce non-competes. With that, I'm going to hand it over to Kate, who's going to talk to us about our number 9 development of the year. Pennsylvania limits non-competes for healthcare practitioners.
Thanks, Pete. So in July of this year, Pennsylvania passed its first statute imposing restrictions on non-competes, but it was, as you mentioned, specific to non-compete agreements between employers and healthcare practitioners, and that term is not surprisingly defined in the statute. And specifically, the act will go into effect January 1st of 2025. So it will go into effect for non-competes that are entered into between those healthcare practitioners and employers after that date. And there are some exceptions to that, which we'll talk about in a moment. And the non-compete itself is defined somewhat broadly, which is agreement that is entered into between an employer in a healthcare practitioner, which has the effect of impeding the ability of healthcare practitioner to continue treating patients or accepting new patients, either practicing independently or in the employment of a competing employer after the term of employment. Notably, the statute does not reference non-solicitation agreements at all, one way or the other. So I think it'd just be interesting to see if there are challenges to what are viewed as broader non-solicitation agreements that potential attorneys might claim are essentially non-competes as defined in the statute. There are some exceptions. An employer may enforce a non-compete covenant with a healthcare practitioner if the length of that non-compete is a year or less, but only if the healthcare practitioner was not dismissed by the employer. There is nothing in the statute that talks about dismiss with or without cause. It's just whether or not the company dismissed the healthcare practitioner. Healthcare practitioner includes medical doctor, doctor of osteopathy, CRNAs, certified nurse practitioner, and a physician assistant. The other exception is that a non-compete can be enforced as to a healthcare practitioner in the sale of the healthcare practitioner's ownership interest, either in all or substantially all of the assets of that business, a transaction resulting in the sale, transfer, or other disposition of the business entity, or the healthcare practitioner's receipt of ownership interest in that business entity. And then the other exception is that the employer may enforce contractual provisions that allow the employer to recover reasonable expenses from healthcare practitioners. We've seen that in some other states where that comes into play. And it's only if the expenses are directly attributable to the healthcare practitioner and accrued within 3 years before the separation, unless the separation is caused by the healthcare practitioner, him or herself, related to relocation, training, and establishment of a patient-based, or essentially spread out over 5 years from the date of separation by the healthcare practitioner. There are also some requirements about notifying patients that the healthcare practitioner has left the organization, and that notice needs to be provided within 90 days of when the healthcare practitioner leaves. There are also specific requirements in the statute about how you provide that notice and which patients should receive that notice, because it's not necessarily all patients. So healthcare organizations should really take a look at those non-compete agreements and what they're entering into before January 1st of 2025. Now passing it over to Dan, who's going to tell us about the Knicks and Raptors case, trade secret case that is the ongoing saga in 2024.
Thanks, Kate. The Knicks Raptors case actually began in 2023. But there were quite a few developments in 2024 for us to discuss. Just as a brief overview, going back to August of 2023, the Knicks were in the headlines. And no, it wasn't because they signed the entire Villanova basketball team to be on their roster. It was because they sued the Toronto Raptors and one of their former employees for theft of trade secrets in federal court in the Southern District of New York. The complaint alleged that the Raptors recruited the Knicks employee, and that prior to the employee's departure from the Knicks, he began forwarding to his personal Gmail account confidential information and trade secrets, including scouting reports and competitive analytics information regarding play calls and team tendencies to run certain plays of competing NBA teams. And according to the Knicks, the former employee allegedly then shared that information with the Raptors, including the Raptors head coach and player development coach. Interestingly, in the case, the Knicks neither filed a motion for temporary restraints nor a preliminary injunction motion. Now, in June of this year, the court granted a motion by the defendants to compel arbitration, and the court referred the matter to arbitration by the NBA commissioner, which is where the case is currently pending. This case serves as a good reminder to employers, as we reported in our November episode of Spilling Secrets, that employers must remain vigilant in protecting their trade secrets, and they should consider conducting a trade secret assessment, not only to understand all of their trade secrets, but to improve upon their practices to detect and immediately respond to a trade secret misappropriation incident, so that they can take immediate legal action seeking temporary restraints and other matters within federal or state court. So that is number 8, the Knicks Raptors case. I will pass it off to Millie, who is going to discuss the Rhode Island governor's veto of the non-compete ban, as well as the same situation in Maine.
Thanks, Dan. So earlier this year, the Rhode Island legislature had passed a sweeping bill to ban nearly all non-competes, both new and existing, except for those tied to the sale of a business. The ban even went further by banning customer non-solicitation agreements, leaving only employee non-solicits enforceable in the state. However, on June 26, 2024, Rhode Island Governor Dan McKee vetoed the bill, citing concerns that it would have made Rhode Island an outlier as compared to other states, which of course is accurate, as only 4 states prohibit non-competes entirely, and Rhode Island's proposed prohibition of even customer non-solicits was particularly rare and extreme. Moving on to number 6, we have a similar development. Maine Governor Janet Mills' veto of Maine's proposed non-compete ban. So back in 2019, Maine had enacted legislation that restricted the use of non-competes to situations involving the protection of trade secrets, confidential information that did not qualify as trade secrets or goodwill, and also requiring advance notice and setting minimum salary thresholds for the imposition of a non-compete. In 2023, the legislature sought to go even further by passing a bill to amend Maine's non-compete law to permit non-competes only if the employee had an ownership interest in the employer or if they were necessary to protect trade secrets. And the protection of trade secrets would only have been an allowable interest if alternative restrictive covenants like non-solicitation or confidentiality agreements were insufficient to protect the employer's interest. However, on March 29th, 2024, Governor Janet Mills vetoed the legislation and stated in her veto letter that non-compete agreements are a critical tool in preventing employees from taking unfair advantage of their former employers, and that the bill really went too far in removing as a protectable interest the protection of confidential information. She also said that the 2019 legislation struck the right balance and imposed the right restrictions on non-competes, and specifically noted that since that legislation was passed, the Maine Department of Labor had received no complaints that would suggest that further reform was needed or that non-compete agreements were somehow being abused in Maine. The governor's veto was sustained by the legislature on April 2nd. And now I will turn it over to Kate to talk to us about our 5th top development of the year, which is Washington State's new non-compete legislation.
Thanks, Millie. So just for quick background on this, in 2020, Washington State enacted legislation restricting the enforceability of non-competition provisions, imposing requirements such as minimum salary thresholds and advance written notice of the terms of a non-compete, among other things. This year, Washington State amended its existing non-compete statute to further restrict the enforcement of non-compete covenants to, quote, facilitate workforce mobility. One of the amendments, the statute's significant changes it broadened was the definition of a non-competition covenant. The original statute defined it to include every written and oral covenant by which an employee or independent contractor is prohibited or restrained from engaging in a lawful profession, trade, or business of any kind. And it specifically excluded a non-solicitation agreement. The amended statute broadens this definition in 2 sort of key ways. First, the amended statute expands the definition of non-competition covenant to include an agreement that directly or indirectly prohibits the acceptance or transaction of business with a customer, meaning a covenant that prohibits an employee from doing business with a customer, like a non-service covenant, is now subject to the requirements of the state's non-compete statute. Second, the new law narrows the definition of an excludable non-solicitation agreement to any agreement between an employer and an employee that prohibits the solicitation of, quote, any employee of the employer or of any current customer of the employer. So the insertion of current means that a non-solicitation agreement that prohibits the solicitation of past or prospective customers may now potentially fall within the statute's reach and the prescribed conduct. The amended statute also imposes more stringent notice requirements upon employers. To have an enforceable non-competition agreement or covenant, the original statute required an employer to disclose the terms of a non-compete in writing to a prospective employee no later than the time of the acceptance of the offer of employment. But the amended statute expands that notice obligation and provides that written disclosure must be given no later than the time of the initial oral or written acceptance of the offer of employment. And so practically, that means that an employer who orally extends an offer to a prospective employee, for example, by phone or immediately following an in-person interview, must provide notice of the terms of any non-competition covenant before the candidate orally accepts the offer. And so practically, HR, practicing in these areas, have companies in those areas would need to know this sort of as part of their ever-changing state requirements about when and how to provide these covenants to applicants. There's also forum selection and choice of law requirements. The amended statute tightens that language. The original statute said it was void and unenforceable if it required an employee or an independent contractor to have an out-of-state choice of law. The new statute replaces and with or. Specifically, it stated, and to the extent it deprived the employee of protections of the benefits of the law. Now it has or, which means eliminating the requirement that both the adjudication outside the state and the deprivation of an employee's rights under the law be satisfied to render a non-compete unenforceable or void. Additionally, the amended statute provides that a non-competition covenant is void and unenforceable if it allows or requires the applicant a choice of law principles or substantive law of any jurisdiction other than Washington state. So again, stricter choice of law requirements under this new statute. And it also expands standing. The original statute provided that only a party to a non-competition covenant may bring the cause of action. The amended statute removes that party requirement and permits any person, i.e. any individual or entity, aggrieved by a non-competition agreement to bring a claim. So in other words, under the amended statute, a prospective employer could potentially sue a prospective employee's former employer to challenge a non-competition covenant. So I'll hand it over to Dan for number 4 on our list, New York City City Council proposed non-compete ban.
So earlier this year, the New York City Council proposed 3 non-compete bills. The first and most significant, Bill number 140-2024, would bar employers in New York City from entering into non-competes with employees, both on a going forward basis and also by rescinding any existing non-compete agreements. Employers would be liable for a $500 civil penalty for each violation of this bill. The second, Bill number 146-2024, focuses on low-wage employees who are non-exempt under the FLSA and who earn less than $1,300 per week. Non-competes for such low-wage employees would be prohibited. For other employees, the employer would be required to provide notice to employees that they may be subject to a non-compete at the beginning of the hiring process. The third bill, number 375-2024, would prohibit non-competes for freelance workers unless the worker is compensated by the hiring party during the non-compete period. A freelance worker is defined as a person who is hired or retained as an independent contractor to provide services in exchange for compensation. Freelance workers would not include sales representatives under the New York labor law, a person engaged in the practice of law, a licensed medical professional, or any individual or entity admitted to membership in the Financial Industry Regulatory Authority, or FINRA. The bill would create a private right of action for the freelance worker to seek a declaratory judgment voiding the non-compete, statutory damages of $1,000, and reasonable attorney fees. It also would allow the city's corporation counsel to seek a civil penalty of up to $25,000 for a pattern or practice of violations. All of these bills were referred to committee and have remained there without further action. Of course, we will continue to monitor these bills for further action by the New York City Council for the remainder of the year and into 2025. And as we move into 2025, employers should remember that now that the FTC non-compete ban is essentially dead, it is more and more likely that states and local governments will introduce legislation, as Millie discussed with Rhode Island and Maine, that will seek to ban or restrict use of employer non-compete agreements. So that was number 4. I will now pass it over to Pete for the number 3 item in 2024, the NLRB General Counsel's campaign against non-competes.
Thanks, Dan. But before we get there, let me ask you a question. Do you have any insight as to the likely future for these 3 New York City bills?
I think that the purpose of them introducing all 3 of these bills was, they've got their home run shot of barring all non-competes and rescinding any existing non-competes. I do think that there is a shot somewhere in the middle where there will be, such as 146, 2024, something such as getting a bill passed where employers have to have a minimum salary and provide notice to their employees. I think that is likely to pass, but given the status of New York, it wouldn't surprise me if something a little bit more employee friendly does pass in 2025. But it's been since early 2024 that these bills were introduced, so it is certainly possible that they will remain dormant.
Thanks. I just think it's interesting because in the paid leave context, we started off with paid leave laws at the state level, and then we have subsequently had multiple local jurisdictions, for example, here the city of Chicago and Cook County have enacted their own paid leave ordinances. And I'm wondering if this is a development that we might be seeing in the next 1 to 5 years in the non-compete space as well. That being said, on to top issue number 3 of 2024. As Dan said, the NLRB GC's campaign against non-competes. On October 7, 2024, National Labor Relations Board General Counsel Jennifer Abruzzo issued a general counsel memo signaling that employers could face civil prosecution and significant monetary remedies for using non-compete and so-called stay or pay provisions in agreements with their employees. In her October 7, 2024 memo, Abruzzo urged the National Labor Relations Board to find that non-competes with employees who are subject to the NLRA's jurisdiction, that is, non-managerial and non-supervisory employees, violate the NLRA, except in a few limited circumstances, arguing that such provisions are frequently self-enforcing and deter employee mobility. The October 7 memo also took aim at stay or pay provisions, i.e., agreements requiring employees to repay their employers for certain expenses in the event that they voluntarily or involuntarily separate from employment. Common examples include agreements requiring employees who depart within a certain time frame to repay training costs, education expenses, and sign-on bonuses, either in full or on a prorated basis. Abruzzo argued that such provisions infringe upon employee rights in violation of Section 7 of the Act by potentially suppressing protected concerted activities and acting as coercive restrictors of employee mobility, which is not a legitimate business interest, according to her. According to the memo, Abruzzo will urge the board to find stay or pay provisions presumptively unlawful. Although General Counsel Abruzzo's memorandum does not represent current law, it does represent direction to the agency's regional directors in terms of enforcement priorities and general enforcement posture. As such, the memo could set off a new flurry of unfair labor practice charges leading to NLRB investigations against employers in response to unfair labor practice charges filed by current or former employees seeking to be freed from restrictions in their agreements. But all that being said, General Counsel Abruzzo will almost certainly be promptly terminated by the Trump administration, such that her memo will likely not be long-lived. However, at the moment, it is alive and well. And with that reference to the election, I have the perfect segue to our top 2 topics for 2024, which Eric Wybust is going to tell us about. Eric, take it away.
Thanks, Pete. So our number 2 topic, I think, was actually our number 1 topic last year, and that's the FTC's non-compete ban. Folks will remember that in 2023, in January of that year, the FTC proposed a non-compete ban. There was subsequently a comment period in which the FTC received over 26,000 comments, including several that we filed on behalf of state and local chambers of commerce and national industry organizations. Earlier this year, the FTC finalized the rule and issued its final rule, and there were promptly 4 lawsuits filed against it. The first was filed the day that the final rule was promulgated, and that was by a company called Ryan LLC down in Texas. The next day, the U.S. Chamber of Commerce filed, also in Texas. And those 2 cases were effectively consolidated in the Eastern District of Texas. The day after the U.S. Chamber case was filed, a company called ATS Tree Services filed a case in Pennsylvania. And then several weeks later, the Villages, the senior living facility down in Florida, filed a lawsuit as well in the federal court in Florida. The litigation is ongoing. We filed amicus briefs in all three cases. Actually, Kate, Millie, and I, along with our associate Carolyn Bochek, worked on those for 11 national industry organizations. We argued that the rule was arbitrary and capricious, and we submitted those, as I mentioned, in all three of the litigations. Before the final date of effectiveness for the rule, we got three different rulings from three different courts. The first was from the Texas court, where they found that the FTC does not have substantive rulemaking authority and that the rule is arbitrary and capricious, and therefore struck down the rule. In the Pennsylvania case, the court came to the exact opposite conclusion and found that the FTC does have statutory rulemaking or substantive rulemaking authority. In the Florida case, the court kind of split the baby and said, well, they may have substantive rulemaking authority, but we're still going to issue an injunction, but that injunction is going to be limited to the villages, not a nationwide injunction or nationwide setting aside of the rule, as the Texas court had done. Since then, the FTC has filed appeals in both the Texas and Florida case, and the plaintiff in the Pennsylvania case, ATS Tree Services, has withdrawn that case, has dismissed that case voluntarily. And the other two remain on appeal. What will happen with those is yet to be seen, but that's a good segue into our final number one topic for this year, which is the possible impact of the 2024 presidential election on non-competes. When we talk about the politics of non-competes, we need to start from the premise that this is not necessarily a Republican, Democrat, blue state, red state issue. If you look at the states that have banned non-competes, two of them are the bluest or the most employee-friendly in the country, being California, which everybody knows about, and Minnesota, which is the most recent state to have banned non-competes in 2023. In fact, the only state that's done so in over 100 years. Whereas two other states that ban non-competes are two of the redder states, Oklahoma and North Dakota. So it's not necessarily, like I said, a red state, blue state divide. What's more common recently over the past 5-10 years is states reaching compromises. And that includes in some of states where bans were proposed, non-compete bans were proposed in very employee-friendly states, including Massachusetts, Illinois, Oregon, Washington, and others. And that seems to be more of the trend in terms of what legislatures across the country are doing with non-competes and what you might see out of Congress, even though Republicans have taken even more of a lead in the Senate and maintain their majority in the House. Doesn't necessarily mean you're going to see pro-business laws. You probably see more compromises if the federal government can get out of its own way and do anything on the legislative side. On the executive side, of course, President Trump won the election. There's not much the president himself can do with respect to non-competes, but his appointments to these agencies we've talked about can be very important. For example, the NLRB and, of course, the FTC. Lena Khan is the current chair of the FTC. She is likely to be ousted relatively quickly once the administration starts in January. What we're hearing is that the new chair is likely to be one of the existing Republican FTC commissioners, both of whom, by the way, submitted dissents to the final rule and suggested that the FTC does not, in fact, have substantive rulemaking authority and it shouldn't be regulating non-competes. That being said, Trump ran on a very populist platform. Matt Gaetz, who was very shortly his nominee for the Attorney General, actually filed an amicus brief on behalf of the FTC's rule in one of the cases. And J.D. Vance, who will be the vice president, has come out in favor of Lena Khan. So it's yet to be seen what will happen with those appointments. It's yet to be seen what will happen with the appeals, whether the government will continue to pursue them. We'll just have to wait and see. And perhaps next year at this time, we'll be reporting on what the Trump administration did as opposed to what we expect them to do.
Well, it's certainly going to be another interesting year, Eric. It's going to be fun to see what does happen in Congress and in the executive branch. Thanks to everyone for joining today. It has been another fun year of spilling secrets.
Thanks, Pete.
Thanks, Pete.
Thanks, Pete.
Thanks, Pete.
Okay, a special thank you to our listeners. If you would like to subscribe to Spilling Secrets, please go to ebglaw.com/subscribe and click the box for Trade Secrets and Non-Competes /Spilling Secrets podcast series. Thanks again, everyone, for joining. Until our next episode, this is Pete Steinmeier signing off on behalf of the Spilling Secrets team.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.